Hi, everybody. My name is Peter Biebring, and I am Senior Counsel with the ACLU of Southern California. I am sorry that I could not be there with you today, but I have recorded this presentation on California laws that passed last session that affect access to police discipline records. I hope will be useful for the discussion. So I will be focusing on two bills that passed last session. The first of which is SB 16, which is a follow-on piece of legislation that basically modifies SB 1421 to expand the categories of records that are available and in some other important ways ease access to those records. The other bill I'll be talking about is SB 2, which is a bill that primarily created a system to decertify police officers who engage in serious misconduct, essentially creating a state licensing scheme where peace officer licenses can be revoked for serious misconduct. But there are some important aspects of that that do affect public access to police disciplinary records, which I will talk about. We will start with SB 16, which I think is a little bit more straightforward in how it modifies public access. So SB 16 was a follow-up to SB 1421 by Senator Nancy Skinner, the same senator that carried the original bill. That bill, of course, passed in 2018, was a significant grassroots effort by a large coalition, the same coalition that was behind SB 2 this year, that for the first time opened peace officer discipline records to the public in California. Senator Skinner advanced this bill and ultimately passed it to do two things. First of all, to expand the categories of police disciplinary records that are available under Penal Code 832.7 beyond what was available under 1421, and to make some adjustments to make accessing those records easier and navigate some of the obstacles that people have encountered in requesting those records for agencies. So I'll go through each of those. So I'll start by discussing the ways SB 16 expands the categories of discipline records that are available to the public beyond what's currently available under SB 1421. Of course, SB 1421, as most of you I'm sure know, requires the disclosure of discipline records related to serious uses of force, those that involve a firearm or result in great bodily injury, whether or not those are found to be excessive force or out of policy force, as well as findings that an officer violated policy related to dishonesty or related to sexual assault. SB 16 broadens beyond those categories. It preserves those categories. Those remain available as they were under 1421, but SB 16 adds some additional categories. First, excessive or unreasonable force that isn't included within 1421. So that's force that doesn't involve a firearm or results in great bodily injury, but is ultimately found to be out of policy, so sustained as excessive or unreasonable force. So that would be a low-level use of force, like a punch or something like that, that was found to be excessive force. SB 16 also allows for public release of sustained findings of an officer's failure to intervene in excessive force. That is now, of course, a requirement that agencies require officers to intervene in excessive force by another officer under SB 230, which passed in 2019, and violations of that, agency findings of violations of that will be disclosable. The bill also requires making public findings of unlawful or out of policy search or arrest. That's potentially a very broad category because of the large number of searches and arrests conducted by officers, and the number of complaints or the number of times that the legality of those are at issue in criminal cases. So that's potentially quite a broad new category. Finally, SB 16 expands to require disclosure of a sustained finding of biased remarks or statements. The way that this is worded in the statute is a little narrow. It's really limited to bias in writings or internet posts or gestures. And it's not written in such a way that I think it will encompass findings of racial bias in an officer's conduct, like racial profiling, but any kind of overt bias, like a statement or an internet post, would be covered. SB 16 also does a number of things to help facilitate access to police discipline records, and to help navigate some of the obstacles that we've seen arise with requesters who sought those records under SB 1421. The biggest of which is that the bill for police discipline records specifically requires disclosure within 45 days of the request, unless the agency is withholding records based on the exemption for pending investigation under 832.7b8. If you've practiced under the California Public Records Act at all, either as a journalist or advocate or as an attorney, you know this is a big deal. The Public Records Act doesn't provide a specific timeline for the disclosure of records, other than saying that disclosure should be prompt, which, as interpreted by most agencies, is pretty meaningless. So to have a 45-day timeline is potentially a very big deal, and will really help dislodge these records. The bill also clarifies that costs charged by an agency cannot include the cost of searching, editing, or redacting. That is hopefully a clarification of existing law, but certainly a clarification that is useful. We've definitely seen agencies trying to charge costs for these functions inappropriately, in our view, under the Public Records Act. SB 16 also places an interesting limitation on the use of attorney-client privilege by excluding use of the privilege for factual information provided or discovered by an attorney. And essentially what this is doing is trying to close a loophole that some folks were concerned existed, that an agency could avoid disclosure by having an attorney conduct an investigation, by making factual information provided or discovered by an attorney disclosable, notwithstanding the privilege, that essentially avoids that loophole. Finally, the bill changes the retention period for sustained misconduct from 5 years to 15 years. Obviously, to the extent that agencies have already shredded misconduct records, this won't take effect, but over the long run, this will make misconduct information more available. So that's essentially SB 16. We can shift gears a little bit now to talk about the SB 2 and police decertification. SB 2 creates a statewide system for revoking peace officer certification for serious misconduct. It was a big bill sponsored by a broad grassroots coalition, essentially the same coalition that sponsored AB 932 in 2019 and SB 1421 in 2018. That includes the Anti-Police Terror Project out of Oakland, Black Lives Matter California, Communities United for Restorative Youth Justice, or Courage, out of Oakland, California Families United for Justice, the STOP Coalition, the Youth Justice Coalition, the Alliance for Boys and Men of Color, Policy Link, and the ACLU. So these co-sponsors, operating under the umbrella of a coalition called the Let Us Live Coalition, have been really driving a lot of the major police bills over the past several years. Um, SB2, although it creates a decertification system, it also will have ramifications for availability of records of officer misconduct. And I'll talk a little bit about how. So basically, the bill creates a statewide licensing system that's administered by the Commission on Peace Officer Standards and Training, or POST, which currently deals with peace officers training, but will be significantly expanded under the bill to deal with the certification of officers and the investigation and of potential misconduct that could result in decertification. The bill allows POST to define grounds for decertification subject to some guidance that I'll talk about in the bill. And those grounds are likely going to be broader than what is made public under Penal Code 832.7 as set forth in SB 1421 and SB 16. And importantly, the bill also creates a system for hearings on decertification that are going to be open to the public, both the proceedings and the record of those decertification proceedings will be open. And that will help provide a different and slightly broader, I think, set of records. Importantly, the bill also requires POST to create unique identifiers to track officer misconduct across agencies. So every officer is now going to have a unique POST identifier once they become a peace officer, and if the officer transfers to a different agency, that identifier will follow so that POST can track misconduct from one employer to another and still get a sense of when an officer might be a repeat offender that should be decertified. But obviously that'll be helpful for public records for the public to track officer misconduct as well from agency to agency. So let's talk about the categories of what is serious misconduct. Now, the bill does essentially delegate to POST the authority to define serious misconduct. So some of the definition will be refined through regulations that we'll see come out over the next year and a half. But the bill sets forth 9 categories that POST is supposed to use to define serious misconduct. Those include, first, dishonesty, which is defined in a way that largely parallels SB 1421. Second, abuse of power, which the bill identifies as intimidating witnesses, eliciting false confessions, or knowingly making false arrests. The bill also talks about physical abuse, excessive force. I think this is largely going to track what's available under SB 1421. For it to be serious misconduct, it would have to be excessive force or uses of force that were found to be unlawful or out of policy. So that would be already available under 1421. Similarly, sexual assault is one of the categories, and that is defined by reference to 832.7. So that's going to overlap. But the remaining categories are different. They include conduct demonstrating bias, which is a little bit different from the bias set forth in SB 16. As I said earlier, that is defined really in a way that limits it to remarks or gestures, but not bias demonstrated by policing conduct like racial profiling. SB 2 defines the bias that can result in decertification to include biased conduct that would encompass racial profiling. There is also a catch-all in the bill for unlawful acts that are so egregious or repeated as to be inconsistent with a peace officer's obligations to uphold the law or respect the rights of members of the public. So this is a way that POST can essentially define misconduct that might not fall within the other categories. Obviously, this is something that, if misconduct arises through this, will be outside of what's available in 1421. The bill also defines participation in a law enforcement gang as grounds for decertification, as well as failure to cooperate with an investigation into police misconduct and failure to intercede in excessive force. That last one is probably already covered by SB 16. So I want to talk a little bit about the decertification process under SB2 and exactly how records will become available to the public. And I think for our purposes, we can divide the process into 3 steps: the reporting of discipline information by agencies to Post, the investigation by Post of potential decertifiable conduct, and hearings on decertification or suspension conducted by Post. So let's start with the reporting requirement. And at the outset, I think it's worth noting SB2 really anticipates that the whole decertification scheme is going to piggyback off of agencies' own discipline investigation process, their IA investigations, and their complaint systems, and that agencies will report any possibly decertifiable misconduct to Post. But importantly, the bill does not wait for misconduct to be sustained by an agency for it to be reported. It requires that not only the results of investigations and any discipline imposed be reported, but actually even that complaints or even allegations of misconduct be reported to Post, even before the investigation is conducted and whether or not the allegation of misconduct is ultimately sustained. It also importantly requires that any investigations that are resolved by resignation or settlement also get reported as such to Post. So Post knows when an investigation is terminated because the officer quit, or knows, in fact, when an investigation is terminated in a settlement that calls for the termination of the investigation in exchange for the officer's resignation. This is actually going to be a huge amount of information. It is a veritable fire hose of information, represented here by a fire hydrant icon without a fire hose, but you get the point. It's a tremendous amount of information that is going to be required to be reported by agencies to Post, and Post will have to kind of be able to pick through that and decide what to investigate for potential decertification. But at this point, everything is still confidential. Everything that's reported by agencies to Post under Copley Press is probably is going to be still confidential. The next stage of the process is really the investigation by Post. Of course, agencies probably, for the most part, Post will wait until agencies have completed their own investigations, and certainly target, for the most part, investigations where the agency has found serious misconduct. But they Post can review the agency's investigative file. The SB2 creates a new division within Post that's an investigative division that can review the agency's file. They can also conduct an additional investigation if that is necessary. And ultimately, the Post investigative division is tasked with determining whether there are reasonable grounds for revocation or suspension. Up to this stage, though, the Post investigations are also confidential. It's the last stage that has potential impact for public access, the hearing stage, because if Post investigators find reasonable grounds for revocation or suspension, they forward the file for a hearing by a Post advisory board on whether to recommend suspension or revocation. If the advisory board recommends revocation or suspension, they'll be reviewed by the full Post Commission and ultimately a hearing by an administrative law judge. But all of these hearings by the advisory board, by Post, and by the administrative law judge, as well as any records introduced, will be available to the public. So that will be the potential source of public information that SB2 creates. So basic summary, just to go over what we talked about. SB 16 expands 1421. It broadens the categories of disclosable misconduct to all sustained excessive force, sustained failure to intervene, and sustained findings of unlawful search or arrest or biased remarks. It also requires disclosure within 45 days if the agency isn't withholding based on a pending investigation. It narrows the attorney-client privilege, limits the costs that agencies can charge to requesters, and expands the retention period to 15 years for sustained misconduct. SB 2, the decertification bill, creates a unique post ID for every officer, even when they transfer from agency to agencies, which should make it easier to track misconduct by individual officers. And it makes the proceedings and record on hearings for suspension or revocation public. Those hearings occur if post determines that there are reasonable grounds for suspension or revocation. The categories of misconduct, although they will be ultimately established by post through regulation, are provided for in the bill, and they're somewhat broader than the categories of misconduct that are available under SB 1421 and SB 16. One final note on this: how easily available those records are, how easily available the hearing transcripts are, the records that are introduced in the hearing, will to some extent be up to post. And I think it is worth anyone who is interested in those records paying attention to how post implements the bill. There's going to be probably a lot of work done on post's implementation, and I think records and the availability of records will be pretty low down people's list since they're setting up these new investigative divisions. So if agencies that are, anyone who's interested in availability of records wants to pay attention to that and call the agency's attention to the importance of making sure that those are publicly available, both for the sake of transparency and perhaps more persuasively to post, so that they are not inundated with ad hoc public record requests for transcripts and records. I think that would probably be helpful. So I hope this has been useful, and I look forward to everybody using these bills to get access to public records in California.